Judge Zone, welcome.
So good morning, thank you.
Patience.
Oh, of course. So Tom Zone, Chief Superior Judge. I've had an opportunity to review the draft, and I'm working off 2.1 of S-195. I think it would be helpful to just set forth right up front that what can happen now. In other words, the bill sets forth a number of processes and changes, but right now, if someone is released on conditions and they violate conditions, the state has the opportunity to file an information against them alleging that they are in contempt for the violation of conditions, what we commonly call the VCR. Under the law, when a VCR is filed under 13 VSA 7559 subsection E, it says that the last sentence says, upon commencement of a prosecution for criminal contempt, which is a VCR, the court shall review in accordance with section 7554 of this title and may continue or modify conditions of release or terminate release of the person. And so I point this out because currently, when someone comes before the court, it has the opportunity to, and an obligation to look at the original case and say, okay, are these conditions still meeting the requirements of 7554, and to go back and relook at them with the new information. And so this S-195 bill sets forth an entire procedure about, well, the court can do X, Y, and Z, but we can already do that. And it's a very simple process. Defendant comes in, we say, okay, it's a VCR, and the judge should look at the conditions and decide what conditions are there. I can tell you that, for instance, how this can work in practice is if someone has a felony that would otherwise qualify for being held without bail under 7553A. And let's say they were released because the court concluded that initially that burden had not been met. I have had cases where if someone has violated a condition, I have concluded that under 7559E, I'm looking back at that original charge and saying, even though we didn't hold without bail previously, when I'm looking at those conditions, under 7553A, we're revoking the conditions in terms of release. We're holding this person without bail, and we're now going to treat it under that analysis. And so when we're looking at the bill today, I just want the committee to understand that we do have these tools to alter and add conditions, and the conditions that can be imposed are ones that are going to be dependent on other parts of the bill. And so when we're looking at that, if you go to page 2 on line 12, this affects the $200 limit on bail. It says the $200 limit shall not apply to an offense committed by a defendant who has been released pending trial for another offense. This, I think it's fair to say that $200 is insurmountable for some people to pay, and it's very, very low for others. But that's a policy decision for the legislature about the amount. But for the individuals, where it says release pending trial for another matter, in the middle of the night, law enforcement might not know this. They may just have someone who has violated, who has committed a crime. Because if they're released on recognizance, they don't have conditions. So it might be better to say the $200 limit shall not apply to an offense. It should actually say charged against the defendant, because this assumes where it says committed by a defendant that they've actually done it, and we all know that the information is merely an allegation. And so if it said that the $200 limit shall not apply to an offense charged against the defendant who has been released on conditions or released on recognizance, that could work. But again, the $200 issue, that is straight policy for the legislature.
I'm sorry, go ahead.
Senator Norris. And
just a quick question, Judge. So in reference to our previous attorney testified, he had mentioned to a defendant who has fled. Is that applicable here, or is that not applicable? Is this fine the way that it's written, or?
Shall not apply to an offense committed by who has been released pending trial for another offense. Well, I think what he may have meant is that they may have never been arraigned, And perhaps then he wants to open it up past $200. But if someone has fled and that's a violation of their conditions, that would be, they would have been released pending trial for another offense. And if that, and the violation of conditions could be an offense. So I don't know why they would need it, that language necessarily,
Okay, thank you.
unless they're intending to capture another group.
I think it came to a constitutional issue or something he had mentioned, or?
Yeah.
So, all right, thank you.
That was my question too. So.
Okay.
Yeah, what Marshall had said is that limiting, like, making this about cash only bail in this situation where it's a constitutional issue, you didn't tie it to risk of flight.
But that's what the initial part talks about. It already is tied into the risk of flight because that's the section. And you can't impose bail for any other reason. On page 6, at the bottom on lines 15 through the end of the page onto page 7 is the new language. I think it's fair to say that these factors that the legislature is adding are already generally considered by the judges. So we take no issue with them being added. The one line that I do have a question about is the very last line on 21, whether the accused is currently compliant with any standing court orders relating to the, protecting the public. I don't know what that means. Generally, a standing order is a procedural order issued by the court. For instance, the Vermont Judiciary on our website has a location of standing orders which set forth for all the courts who put up these orders what the rules are for remote hearings and things like that. So I don't know what that line means. So I wouldn't be able to really interpret it as a judge, I guess.
It was meant to cover, risk protection orders, things like that, and also any other orders that, for violations of conditions that were.
So you would delete the word standing.
Right.
And I think that gets us where it makes sense then. That makes sense. On page 7, line 12, and this is actually current language, where it says the person that a warrant for the person's arrest will be issued immediately upon such violation. We don't issue warrants immediately. In other words, I think it should say may be issued when someone violates a condition, because it may be a circumstance where you don't issue a warrant for their arrest immediately, because right now, the statutes don't necessarily provide for that. There's only certain, under Rule 3 and under the statute, there's only certain provisions that you can issue an arrest warrant for. So I think having it say may would address that.
That's current law though.
That's correct.
Judge, where were you seeing that again? Sorry.
Oh, that is on page
7, line 12.
7, line 12.
Okay, thank you.
Yeah. And that, again, that's current law. When I saw that, I think that's one of those things that got in there somehow and it's just remains. On page 10, it's been discussed already this morning, so I won't get too deep into it, but it does delete the ability to use home detention for individuals who have been released on bail. As of today, there are 6 individuals who are currently under that status. I think it's important to point out that a year ago or so, I was asked to testify before House Corrections when they were talking about getting rid of the home detention program. And I carried the message back to the judges about, well, we need to, if you will, use it or lose it. There may be the potential that it goes away if we're not using it more. And so I've had that discussion a number of times. When the numbers have remained low, what I have learned when I've gone back and asked is that oftentimes when someone is going to apply for home detention, it gets the parties together at the courthouse. And so someone who otherwise might have been going out on that status resolves their cases. And so it might not, it doesn't, the utilization of the program actually has had another byproduct, and that is reducing the backlog potentially, because it brings people together to discuss the case. If the state thinks, well, we'd rather have them out on status of conviction with sentence as opposed to home detention, It often, and the defendant feels that's appropriate, it oftentimes can help lead to resolution. But again, it's a policy as to whether it's there, but the court certainly supports as many, we keep using the phrase, tools in the toolbox as we can have. On page 11, line 17, it talks about if there's a failure to comply and someone goes back to the correctional facility in accordance with 7575. But that doesn't work. Currently, when someone is released on home detention, that is conditioned on, because they have not posted bail. And the condition is, you are allowed to participate in this program if you follow the rules. You can't participate in this program if it's determined that you violated the rules. And if you violate the rules of the program, you go back to the status that you were in, which is held on bail. And so DOC has the ability to take you back and put the individual in custody because they haven't followed the program. DOC does not have the ability to under the program to say that we are revoking your bail. They have the ability under the structure of the program to put the person back in their status that the court had ordered. So if you change the program requirements to allow them to bring in other individuals for violations, that still does not change the fact that DOC is not a party to a 7575 proceeding. A 7575 proceeding would require that there be a filing made to revoke conditions of release. DOC doesn't have the ability to take that person and incarcerate them. Does that make sense?
Well, I mean, yes and no. Does it make sense? Yeah, but is it the right thing?
Please understand that my comments are as the law is,
Right,
not as people may want it to be.
Just about the home detention program, so you would agree that it's important to have it available for everybody?
I think it would be, yes.
So I think there's general agreement that it shouldn't be restricted just to people who violate conditions.
So when we talk about violations of conditions, on page 12, under 7554E, this sets up the entire process. Now, at the start of my testimony today, I mentioned that we have the ability under 7559E to change conditions and modify them. As you heard, plain language says we can do that. In effect, this statute is a very long way of doing the same thing, adding conditions that might be deemed appropriate, and it adds a number of procedural manners to do that. If the legislature as a policy wants to go in that direction, that's certainly fine. But when you're looking at this statute, there's a few areas that would, to this procedure, I think need to be addressed. Under subsection 2 on lines 8 through 12, it talks about the person has to be arrested or cited in accordance with Rule 3 to appear before the court in which the conditions of release were ordered. Under Rule 18 of the Rules of Criminal Procedure, the way it works is if someone has conditions out of Rutland and commits a crime in Bennington, and engages in violation of conditions in Bennington, they can be seen in Bennington and they can be cited in Bennington by the state's attorney to get them in right away. And then if there is no new crime alleged in Bennington, under Rule 18, the case is automatically sent back to the county where it's transferred back to the county where the conditions were imposed. The officer also has the ability to do it directly, in that example, in Rutland without having to go through Bennington. So this would statutorily change the existing rules and the way things currently work. The
Question for you. Would it change in such a way that it would worsen the backlog, or would it, what effect would the change have?
What I think could be a theoretical benefit of the change is that it goes back to the same county where it originally started and the judge gets to see it at that exact moment. The negative is that if you have someone commit a violation and they're living in a county that's a county or two away, it's sometimes good to get them right into court the next day. And there's provisions here that talk about the importance of getting someone in. getting them in that county is a good place to go. The other problem is, it actually would possibly, if you had someone who had a violation of conditions and a new charge in the same county, you're then sending it back to another county, and you're requiring the witnesses from Bennington to have to go to Rutland, or vice versa. And you're splitting the cases. And that's what Rule 18 was designed to try to alleviate, to make sure that it can go in either place. And the state's attorneys, I think, have been pretty good at working out where the cases go. We transfer it right back. But there have been times, I'm aware, where the state's attorney would say to the officer, we're not filing it in our county, file it up in the county where it happened. So
I can see how splitting the case like that could be problematic in, one, creating more of a workload, but also the challenge of just making sure somebody's appearing in court, because, the more hearings you have, and the more challenges somebody might have for appearing, whether they don't have access to transportation or, things like that. The more hearings you have, the greater increased risk of somebody not appearing. So.
Absolutely
So
correct.
specific to your recommendation, would your recommendation be to strike Rule 3 and put in Rule 18, or would it be to Rule 3 or Rule 18?
The person may be arrested or cited I think it's missing a word. It should be appear. It says to in on line 10.
Mhm.
To appear in accordance with Rule 3 of the Vermont Rules of Criminal Procedure, and you could even just put in Rule 18 of the Rules 3 and 18. That would, I think, get you where you need to be. So the other issue that comes up now is when someone currently violates a condition of release and it comes back before the court, it's charged as an information, which is a charging document. Information is supported by affidavit. Our rules of procedure provide that the judge can issue a warrant based upon an information and affidavit being filed. Section 4 doesn't tell me what's going to be coming before the court. In other words, there was talk in the testimony earlier this morning about when the person first comes in, is it going to be a status conference? What are we going to do? Well, what's left out here is there going to be a charge? If there's an information, that's a criminal charge. If it's going to be a summary proceeding, is the criminal charge what starts that? Does that make sense? That it doesn't tell the court what I'm expecting to see. When I see a charge, I'm thinking, okay, the state has elected under 7559E to bring a criminal charge. Because that is the way that you proceed with the case to get the case before the court. But I don't see what process is being used, because if the state comes in and they file that, I suppose it could be, well, the state has to file an information. And then once the state files it, the state shall notify whether it decides it wants to go forward under 7559 or under 7554E. But there's a problem with that. The problem is the judge can say, under this statute, we're going forward under 7554E. And the state can say, but judge, we want to charge the person. We want that extra time. And we want the conviction. And under this, it says the judge can decide that it's going to be a summary proceeding, and the judge can say, nope, we're doing a summary proceeding. So there's something called separation of powers, that this is actually letting the court theoretically decide whether the state gets to prosecute something or not. The other issue with that is when I mentioned at the beginning of my testimony, when someone comes in under 7559, under a violation being filed by information, we can amend the conditions of release. Well, if this says that you have to either go under the summary procedure or 7559, and the person comes in, I guess I don't have the authority to change their conditions of release immediately. But we heard Mr. Paul talk about the fact that they need time and they need to have things go. So do we just have to leave the existing conditions in? Because currently what would happen is I'd look at the case and go, okay, let me hear what you have under 7554G. Let me hear what you have for information. We look at what's before us and we decide what conditions there are as far as new conditions. But you're building in the potential that there's a complicating factor. They can't do that.
So we should go back to current law.
I think,
Right.
I'm not saying you should go back to current law necessarily, but what I am saying is we do have procedures in place that address many of these things, and by building in these procedures, what 7554E also does is you add thresholds. You have to find this, you have to find that.
Then we'll redraft and draft 3.1 and then see if that works. How's that?
Oh,
Or
works for me.
Did you want me to strike it or revise it?
I think revise it to Judge Zonne's suggestions.
Okay, well, I can circle with the judge.
Yeah.
And then, and again, when you start looking at upon finding that the person has violated conditions of release, you've added a threshold there that doesn't currently exist for the court to be able to modify conditions of release under 7559. That's a policy decision, but I wanted to I think it should be understood that it does start adding thresholds and things that need to be met, that currently we have the ability to modify conditions. And then again, I already mentioned the exclusive remedy, that's up to the parties. Electronic monitoring, we support that on page 15. I note that it does provide for 24/7 coverage. DOC currently doesn't do that, I think, for inmates that are in custody, but we certainly would support that.
They're much more limited than what we envision is back to Sheriff Clark's Woodland County pilot project, which provided 24/7 monitoring and had, immediate consequences if somebody was in a place they shouldn't have been or whatever.
I had, when I was in Rutland, I remember I had an individual on that program and I thought it was it was a very good option.
Yeah.
And my understanding is that it worked well.
Yeah, what's frustrating here is sometimes we get we do reports. We actually look at them. We have a successful program and we do away with the program.
So we
And because the department doesn't want to spend the money anymore. But it kept people out of jail. I know maybe it's the same case, but it was a guy from Bennington, who was a truck driver for a furniture company. They transferred him to the Rutland furniture company instead of the Bennington one, allowed him to continue to work, pay child support, pay taxes, and all on electronic monitoring, and it was very successful. And so, all the time he would have been in jail for domestic violence, he was out being productive. And I think that's the success of the program, and we do away with them because we can save money by not doing home detention, but we can put them in jail. And it doesn't cost us any more because we have the bed anyway.
I think you've just given me a good segue into the next section with your comments, which I agree with. And this is under the pretrial supervision. Now, certainly pretrial supervision is a policy decision as far as the resources and how the legislature wants to apportion them. I think that as far as when you look at people who are violating, it's not the vast majority, it's a number of individuals who we appear to hear about frequently. I maintain, and we're taking steps to address the issue of the best way to how we move forward, and that is we need to shorten the time between someone's first day in court and the disposition of their case. Many of these issues, I think, will be minimized, if not dissipated, and go completely away if we are able to shrink that time, and we are making gains there. The longer someone's out on conditions, the greater the opportunity is for something to go wrong, if you will, and for violations to occur. And so when you were speaking before, and you were talking a few moments ago, Senator, about we see something that works, and then we're concerned about funding or resources, it goes to the topic that Senator Biaski mentioned, and that is this is not available to someone on day one. So let's assume that you have an individual who has many, many cases in the past, and they come before the court. And most people would think this person has so many past cases that they should be held. Well, we know that under 7553 and 7553A, if they don't qualify, if it's an unlawful trespass, retail theft, they're not allowed to be held without bail. because of their record and their history. And we know that they can only be held with bail up to $200, and that's only to minimize the risk of flight. So if they have $200 and you impose that, they walk out the door and there's nothing that you can do about it except impose conditions. If they don't have $200, then they could be detained. Or, as often happens, the court, through the exercise of its discretion and applying the facts to the law, genuinely concludes that while there may be a desire for consequences by the state and others, the reality is we just can't impose bail unless there genuinely is a risk of flight. And if there's not, no matter how many convictions someone has or encounters with law enforcement, the court has to enter an order that does not impose bail. And I would suggest that when you have individuals who raise that type of reaction, they would be a good person if you're going to have a supervision program to have enter into the supervision program. And so by having it only for people who have violated conditions first, I think that you're giving up an opportunity for a sooner intervention that is going to potentially help the person, as opposed to waiting for something that is probably going to happen with someone because they don't have the skills.
Yeah, okay. Let me just, cognizant of the fact that talking with Representative Squirrel on the House Appropriations Committee, who does the judiciary and other criminal justice areas, like I do, that he's talking around $17 million in additional funding in order to deal with all these things, and this is additional funding. So trying to be cognizant of that and not having 12 officers, but if we could limit to individuals like you just described, who have not had a violation, but have a past history of frequent violations, I don't think that would necessarily increase the numbers. We are, in fact, talking about a relatively small number of people who become the news headline because they're continually released on further conditions or whatever. It's not a huge number. So I do think there's still room for somebody you just described, but I'm cognizant of this. I spoke to Senator Kitchell yesterday about this bill and the 6 new positions, and it didn't go over as swimmingly as I would have liked. But, I think if people really want to deal with public safety this year, then there may be things that we can't do in other areas in order to accomplish what we need to do in public safety. It's certainly a core government function.
And so we support this type of program because it's not just catching someone doing something wrong or looking for that. As I understand the program, what it seeks to do is have that as an option for someone to be have oversight, but it also seeks to have someone get assistance. Right. Where do you go for housing or whatever else it is? As I understand it, the supervisor would have the ability to help someone get those resources. And
so to the Department of Labor and see if there's a WIOA job available because of their category. Maybe they're under 25. Maybe they don't have a job.
And so
so I think the design is similar to what, if you, the $1 Million Murray in Reno, you're spending $1 million a year chasing Murray, who keeps violating everything and breaking the law. But if you provide them with a job, a home, and a substance-free life, which they did eventually, it cost about $20,000.
And on page 18 of the program, And I do have in mind Mr. Paul's comments about delegation.
Yeah,
The Vermont Supreme Court has held in the context of probation that the court can't just delegate the probation officer the authority to determine conditions. And so I think it would be helpful to make it clear what the conditions are, to have that and what's expected for enforcement and monitoring. When it talks about that the court may issue a warrant, it doesn't have the process for that. Currently, if someone's on probation, the probation officer can issue a violation of probation and then request a warrant as part of that. This is a little, this just says the court may issue a warrant for the arrest. It doesn't tell us what we need before we do that. And again, generally warrants are done, whether it's violation of probation based upon an affidavit. So it should be made clear in whatever structure is put together what the process is as far as filings to obtain any types of warrants. Also, that's something the state may want to weigh in on, how they see that happening. Do they want the monitor to be filing something exclusive of them? I keep saying monitor, I apologize, supervisor. It then says that the person shall appear for a bail revocation. Well, it might be right out front that everyone knows it's not bail revocation. We shouldn't schedule it for a bail revocation under 7575 if on its face we know that it doesn't even remotely qualify. On page 19, at the bottom line 19, it says a person who complies with all requirements of the pretrial program, not less than, may receive a reduction in supervision level. I don't know what that means. And so I don't know if there's any identified supervision levels anticipated, but, and I agree with what you said, Senator Sears. When you look at least restrictive and levels, people may have differing views. Yeah. So unless there's something spelled out that supervision level A looks like this, B looks like that, I don't think that section gets us anywhere.
Well, I think the idea was the court could take the person off the pretrial supervision. So maybe that needs to be more direct, that after 90 days, the court could review and say, well, he's doing very well, or she's doing very well, and don't need to continue.
It could be upon its own motion or motion of the state or defendant, the court.
I think that's
the
what
court
was
may
intended
terminate
there.
Yeah, absolutely.
Or change the, whatever conditions they may have put in.
That would work. On page 21, when you're looking at, it's under 7575 and it tweaks that. Under subsection C, when it talks about evidence, it brings in the evidence of guilt being great standard, and it appears as though it might be indicating that you could just do it by affidavits. But the Supreme Court in Gates and Sabe have indicated that there may be requirement for something more than just affidavits, and so I would just point that out. I'm not going to tell you that this doesn't meet that, but in those cases, they did touch on the issue of live testimony may be necessary, and to the extent this suggests that you can do it by affidavits like you can for hold without, I don't think that would be accurately stating what the Supreme Court has said. As far as
Judge Zoney, if you wouldn't mind, on page 21, right under that is the section I was looking at earlier under orders. And it says, the court shall not revoke bail based on a breach of conditions of release alone or solely because the accused may endanger the public. But you could, it seems that the language suggests that you could put them together and say, this person presents a threat and they violated conditions of release.
in Sabe, the Supreme Court indicated that, I'll just quote Justice Johnson, what she said. A person may repeatedly violate court orders and commit crimes similar to that with which they are charged. Such flagrant disregard of conditions may show a disrespect for the judicial system, but these violations do not necessarily threaten the integrity of the judicial system in the constitutionally limited sense that they thwart the prosecution of the defendant. Moreover, courts are not without recourse in dealing with those who persistently violate conditions. Proper tools include imposition of more stringent terms of release and initiation of contempt proceedings. The one sanction not available to the court, however, is withholding defendant's constitutional right to bail. To justify a compelling state interest and thereby render 7575 to constitutional, there must be a nexus between defendant's repeated violations and a disruption of the prosecution.
Got it. So, and it's maybe a more philosophical point, but it seems to me, if you're talking about the constitutional provisions and the interpretation of them, that they're making the integrity of the court the North Star and of the proceedings, but not necessarily threats to the public. And so in those cases, they're suggesting that the proper tools would be contempt.
Contempt, but there have been cases where the court has found that under 7575, when you mentioned the safety of the public,
Yeah.
if someone in their case threatens a witness, there was a case where a defendant drove by the witness's house several times, and the court found that that was enough under 7575 to support revocation. And so it's not that public safety is disregarded.
But only where there's a Venn diagram and it overlaps with.
It has to be affecting, as I read, where it talked about the prosecution of the defendant.
Yeah, it's a little startling to see it in black and white that someone can be a clear threat to the community, but you can't use, and violating conditions of release, but you couldn't, you couldn't revoke bail unless it also threatened the proceedings themselves.
The integrity of the judiciary, as has been interpreted by the court.
And so just quickly, your thought about, you've got somebody who is persistently violating conditions of release and you make them stricter and they keep violating them. Is a judge's go-to thinking there that they would go to a contempt proceeding, or is there another way to address that?
The contempt proceeding is the charge.
It is.
The way it's structured under 7559 of Title 13 is that the information that's filed for the violation of condition, that is the initiation of the contempt proceeding.
Okay.
So they're already in the contempt proceeding, and the outcome of that is the jury trial.
Yeah.
Or the resolution of another mechanism. But you are correct. If someone keeps violating, the court comes back to those fundamental questions. When you look at bail, is there a risk of flight?
Mm-hmm.
Is bail appropriate? Or is it a case that someone has violated the conditions in a way that threatens witnesses or the integrity of the system or disrupts it in connection with SAVE? So you're looking at that as far as whether or not you can violate someone under 7575. But oftentimes, the safety issues, I think it was mentioned this morning, if the original case was a crime of violence, you might have 7553 or 7553A.
Mm-hmm.
But for the individuals who keep violating, we'll say the lower end expungable misdemeanors or sealing misdemeanors, unless you find a risk of flight,
Right.
or unless you find that disruption that matches 7575.
Yeah, the problem is that there is no risk of flight. They're just going to stay in one area and keep committing the same crime.
And that is what we need to do in those situations, is what we're striving for, and that is shorten the time between the charge coming in and the disposition. We cannot have people out for such long, extended periods of time, because what we're seeing is additional charges, and they're not getting any correctional treatment that may otherwise be imposed as part of a sentence if they were convicted.
Okay, thank you. That's very helpful.
Lines on page 21, lines 18. The language about including non-compliance with court orders relating to ensuring the court's appearance at court proceedings and a person's failure to appear at court hearings for flight. It's a little confusing, because sometimes you can't really differentiate between the conditions. We don't say this condition is imposed just for appearance, or this condition is imposed just for public safety. And so it's difficult sometimes to discern between the two. So I just wanted to point out, again, when I look at that language, I can see where it could lead to some confusion as to what are we really trying to, including non-compliance with court orders relating to ensuring the person's appearance at future court proceedings. Well, is a requirement that could be imposed of substance abuse treatment ensuring their appearance, or public safety, or both. And so I think there's a lot of conditions that are imposed that would arguably be for both. So I think that language, that line could be somewhat confusing. I think failure to appear at court hearings certainly is clear and makes sense. On page 22, under sentencing alternatives, line 7, where it adds in violations of conditions by the defendant, it just needs to be clear that, to let the legislature know that if it's going to attempt to be utilized at sentencing, the state's going to have to establish it. The fact that someone may have had a charge brought against them for violations of conditions does not necessarily mean that that can be used by the sentencing court. The court can find that it's established by reliable information. On page 24 was where, Senator Sears, you were asking some questions about what's an act of violence for determining bail with Mr. Paul during that discussion. I'll stay away from that. What he's saying is simply that the legislature enacts statutes, and those statutes have to be deemed constitutional. If there are terms utilized in the Constitution, for instance, under Section 40, where it talks about the ability to hold someone for a crime of violence, and it talks about the constitutional protection, the Supreme Court has to apply what the Constitution provides. And obviously the legislature can't go different than the Constitution and say, well, we say this even though the Constitution says that, and the court has the obligation to determine what is or is not under the Constitution crime of violence. And so the court has to make that determination when it addresses those cases. The fact that the court has to make that doesn't mean that it may or may not find this is a crime of violence. It just means that, as I think Marshall was pointing out, his view that the court is going to be the one to make that decision, possibly. Right. And I was not able to look, I was trying to find back to 1993 to find some, what we were discussing, Senator Sears, and I couldn't find much history on that, but I'll keep looking at that.
Well, there was in the decision, there is a conversation about what a new bail amendment was introduced and passed by the legislature in the 1991 document. See Proposal 7. It'll be considered again in 1993 if the majority of both houses concur with second popular vote. Then it goes on to say, Proposal 7 would allow judges to deny bail to those charged with felonies involving violence if the accused release poses a substantial threat of physical violence to any person and no conditions of release will reasonably prevent the physical violence. Senator Bloomer, the chair of the Senate Judiciary Committee, describing the proposal, recognized that this concept to allow persons to be held for purposes of public safety is a new concept for the state. The Journal of the Senate at 402 April 1, 1992, remarks John Bloomer. Unless this new concept is enacted, we must continue to evaluate bail statutes as maintained and discussed in our prior cases. I think what happened was this was part of the SAVE, but it came before the enactment of the new bail statute. And then there was a case after that enactment where Bloomer and Alusi and others went over to argue or to appear, or I don't know if they had any standing or what, but that's where it might not have been in this case where the decision was made, but it was clear what the Senate intended isn't what happened.
Well, there was.
That's what I'm trying to, that's my recollection from 1993. Don't ask me what I had for dinner that day.
Well, the 1793 Constitution of Vermont, and I confess, I found that one and then I jumped ahead to the revisions later, but did not have as the Supreme Court just said in that case, there was nothing in there about the public protection. It was capital offenses. You could hold someone if it was the life imprisonment.
And there's discussion here with John Eaton, he was the Attorney General at the time, who was concerned that it was only, I think aggravated sexual assault wasn't even included.
And so what I hear when you were reading that is the Supreme Court was saying that even though in the past there was nothing coming, there may be a change. That
Right.
change was Section 40.
Hmm.
That change did not do what some states have in their constitutions, which is allows the judge to say that you're a danger in the community, we're holding you. It said crime of felony, crime of violence, element of violence, that you have to then have the other factors found under 7553A, and that's what was adopted. And so it sounds like what may have happened is there may have been an expectation that it was that constitutional amendment had much broader applicability than the plain language of felony. And
there was clearly a disagreement between the leadership of this committee at the time and the final court decision. But this decision came out January 29 of 1993, so it would have been timely with that whole discussion. We got back in session in January, obviously, of 93, and that was my first year, and I had no idea what the hell they were doing.
And the last topic I wanted to touch on.
Oh, there's a text from somebody saying, yeah, you're right, you didn't know.
Section 12 on page 25, the misdemeanor offenses docket. The question that was asked earlier this morning is it a separation of powers to do that? We don't need to go that far. All I will say is this. We would not support a special docket. We don't know what it really is intending to do that we're not already taking steps to do. We have, in terms of addressing the backlog, been employing what are recognized case flow standards for how we're doing things. And this month, for instance, in Rutland, I think our clearance rate is 137%. And this is a reflection of having the extra judges. Bennington, I think we're up to 115. The numbers are going in that direction. Judges are scheduling the hearings with individuals who are attempting to schedule hearings with individuals with multiple charges. I have actually been communicating with judges saying, you have these individuals with multiple cases. What do you, to bring them to their attention? I mean, I'm talking names to say, here's all the cases in your county that have 10 or more violations, 10 or more pending dockets. What's the next step? Are you staying on top of it? Just so we are able to not lose track. These are all techniques and strategies that are recognized across the country for case flow, and we're taking those steps. To do a separate docket, we don't have the resources for that. I'm not even talking about judges. The attorneys who are doing this, who are doing the misdemeanors, are doing the felonies. So if you're taking them and say, well, we're gonna have a special day here for just misdemeanors, well then all the murder cases, the sexual assaults, the child sexual abuse cases, they're not working on those. And what we try to do is to work with the state and defense as best we can to come up with what is that balance that we can strike to maximize getting the cases addressed and minimize the ability of people to say, we can't do that. And so we've been making those gains. To come up with a separate docket, it doesn't really do anything for us in terms of the backlog. And actually, if we had to do something, it probably would even exacerbate the backlog to try to separate things out. We separate out treatment court in Rutland 2 days a month. There's 19 individuals in it. And so that's 2 days that we don't have a lot of people in there. And so sometimes when we're dealing with what we call specialized dockets, we're devoting a large number of resources to a small number of people. This is not that case in terms of the specialized docket, but to try to create a system when we already have the ability to move cases and alter them, we just don't think is the direction to go. We think it would have more negative impacts. And we, as late as yesterday, I'm visiting with, I was talking to the Rutland clerks. We're trying to facilitate having second jury draws in certain counties to do just this, misdemeanors, to get them done. So,
what's the committee's pleasure on this section? Yes, sir.
I don't want to interrupt. I just got a question in reference to what you read this morning from Burlington.
Yeah.
Okay, did you hear what?
I did.
What the chair, so my question is, February 27th, there was an officer allegedly assaulted. If you look at the numerous police engagements with this one individual, and you say shorten the time period, I'm not saying this is your fault, don't get me wrong, but you're here and nobody else is, all
That's
right?
okay.
So, you say shorten the time period. This guy's had 30 engagements in 2024 alone, so that's one engagement every other day in the criminal justice system. He was brought to court for arraignment and released on conditions, and you know the numbers. I have to answer to my constituents and say, how does this happen? The chair has an individual with 64 or 67 VCRs alone in Bennington County, I believe, the second most in the state. So I need to be able to go back to them and say, when they say soft on crime, how does this happen?
I would say, I would look at them and say, the due administration of justice is the firmest pillar of good government. The judges are obligated to determine cases based on the facts and the law. A judge is not entitled to hold someone simply because society is angry with them or that there's a belief that they need a consequence. A judge has to determine if indeed there is a risk of flight. If there's not a risk of flight, and it's not a life imprisonment case or a felony under 7553A, they're entitled to be walking out with conditions.
And that's why I keep going back to the 1993 amendment to the Constitution, which didn't contain what some legislators and at the time the Attorney General appeared to want. And that is, it is a constitutional issue, and that's the problem, is trying to explain the Constitution.
Maybe we should do a constitutional amendment.
Well, that's what I was just thinking, you know, we're running up on a couple of these instances where the public isn't protected because of the structure of the Constitution.
Right.
And I think that's a clear enough argument for, you know, we've got some moving that aren't that closely tied to public safety. And that's maybe where we need to.
Are you looking at tying it into an amendment already existing, or just?
No, I'm just,
Okay.
I'm just thinking that, for the future, it's worth.
Contemplating a new
Discussion.
constitutional amendment.
And I do not minimize by any stretch the idea that people need to understand that we hear their frustration. I get it, but when a judge takes an oath to be a judge, we have to decide matters without bias, prejudice, or sympathy, without public clamor influencing.
And I can appreciate that, okay? I'm not saying it's wrong, but I'm saying that
No, I
my
get it.
constituents are not gonna buy into it.
So,
Okay.
Senator Mahowski, and then I need to get on to 209's amendment.
We can move on.
Okay. So the committee's pleasure. Thank you, Judge.
Thank you.
Do you want to strike the section on the special docket, or do you want to leave it there for further discussion?
I vote strike.
Agreed.
That was a big win for the judiciary.
I'm gonna take that. I'm gonna go back. I'm gonna be excited today. Thank you. Can I ask a question very quickly? And this might address part of your question. Do you think it would help if maybe the chief superior judge did an op-ed to somewhat explain the way bail is? Or do you think that that's something that
I don't
might not be
know if
helpful?
anything would help, but I think it would help to help people in this building anyway understand the constitutional limitations.
That's the
I think there's a lot of misunderstanding even in this building about what the constitutional limitations are.
Well, I think we know what I will be doing over town meeting. Thank you.
Thank you.
Have a great day.
Jay, unfortunately, we're running out of time, and I apologize. But I wonder if you can come back on Tuesday, the 11th. Is it the 11th?
Yeah.
Yes, yeah. No, Tuesday the 12th. Don't come on the 11th. We won't be here. On Tuesday the 12th, and begin your testimony on the bill. And if you have written testimony you want to provide ahead of time, it'd be helpful.
Absolutely. I would be happy to come back on Tuesday, the 12th. I have been working on some written testimony, so I can provide that to the committee before the 12th. I'll work with Committee Assistant Donsbach on rescheduling.
Okay, thank you very much for understanding. Appreciate it. So
Thank
we
you.
will schedule you on the 12th. Yeah, I do have that. Okay, thank you. We're gonna switch gears to S209. There was, some discussion on the floor about the possibility of an amendment. Eric worked with,
Would the committee like their files on 209, or do you just want to
I
look?
just wanted to amend on the first one.
Thank you.
So we have 196 for Tuesday, the 12th.
No, today's also going to be 150 to 285, and then Jay will come in at 8 o'clock.
Whoops, got two here, do you want to?
All right, so mine's right after the other two sections with the temporary.
Yep, exactly. That's where it would come in the sequence.
Yep,
Put Ben in on Tuesday also. Ben Novagowski, not Ben.
No, it won't go back.
Well, you could have.
Okay, I don't have a problem with the amendment. We've already voted on it though.
yep.
Voted against it, obviously. Can I support the amendment now? Would that be protocol? or-
Sure. Yeah, I mean, you can vote any way you
I've done
want.
that.
Yeah,
I've voted yes on an amendment and
It
then
brings
no on the
clarity
bill.
to the bill, that obviously
sure.
some folks support and some didn't, but I mean, I don't have no problem with clarity to the bill.
yeah, and the same on the floor, you can vote for the amendment and then against the bills.
So they're just gonna vote on the amendment today, all right? The bill's already been voted on.
Well, you gotta do third
reading.
reading. Okay,
196.
Eric, you wanna,
Sure.
Yeah, well,
Mr. Chair, is it okay if,
yes, please.
goes ahead?
Sorry.
No problem. Eric Fitzpatrick with the Office of Legislative Counsel to talk to the committee for a moment about proposed amendment from Senator Brute,
Yes.
S209. May remember on the floor yesterday, the issue that came up had to do with because the ghost guns prohibition is not only on possession and transfer, it's also on manufacture. And this amendment is related to that concept, which is that I think people were discussing, well, 2 points related to the prohibition on manufacturing a gun without a serial number. First of all, the firearm doesn't come out of the 3D printer or the manufacturer with a serial number on it. So people raise the issue of, well, shouldn't that language that you already have in there that allows an exception for transporting the firearm to an FFL for serialization, shouldn't that also apply to the manufacturing situation? Because there's going to be a gap in there, the time lag between when the firearm is produced and when an FFL can put a serial number on it. So that was point number one. Point number two was, did the language read literally seem to prohibit actually having the firearm without a serial number as soon as it's printed? In other words, again, it's addressing this time gap because, the firearm doesn't come out of the machine with the serial number on it, it has to be placed on it afterwards. So that language was rephrased a little bit. Thanks to Senator Ruth on that. We had an excellent suggestion for how to wordsmith that. And that's the first piece of the amendment. So you got two pieces. One, a little bit of wordsmithing to make clear that it's not a requirement that the serial number be attached at the moment of manufacture. And secondly, to provide a time gap for a person who does decide to manufacture their firearm at home to bring it to an FFL and put a serial number put on it. So the first language is lines 5 to 8, first issue, I should say, which is the issue of clarifying that the firearm doesn't have to be instantaneously serialized when it's manufactured. The phrasing is reversed a little bit. So it says a person who manufactures a firearm or frame or receiver firearm of a firearm, including a 3-dimensional printer, shall cause the firearm frame or receiver to be imprinted with a serial number by an FFL. See, so it's not saying it has to happen immediately. They have to cause it. They have to bring it, or however it is they're going to make sure that an FFL puts a serial number on it. So that's the rephrasing there. Secondly, the new language is the very bottom of the page, lines 12 to 14. This is an addition to the exceptions. This exception already exists for possession, so it's just tracking that language. So the subsection doesn't apply. In other words, it's not a violation if it's just temporary possession of the firearm or the frame or receiver for the purpose of having it imprinted with a serial number by an FFL.
Is it clear though, if somebody uses that firearm before it's imprinted with a serial number, they violated the law?
Yes, because of the other two provisions.
Yes, the uses of firearm is elsewhere in it's not in the amendment.
But
it
it would
remains.
still, if the person went out and used the firearm, then went to is that the temporary? That's where my concern is. I don't wanna leave a loophole where somebody says, well, it says temporary here, and they went out and used it.
Well, that, just to respond to that, that would not be a violation of this statute, because this applies only to use of an unserialized firearm. But it still would be a 5-year felony, because that would be caught under the other statute that we have under existing law, which is use of a dangerous weapon while committing a violent crime.
Well, even if they weren't committing a crime.
You mean if they take it out and target shoot?
Yeah.
I thought elsewhere in the bill, we prohibited using,
In a crime,
in the commission of a crime.
so you could
Yeah,
still
but I'm
not
talking
target
about
shoot.
just using.
Well, so.
I don't wanna give them.
So as I read this, the temporary exemption is for the purpose of taking it to get a serialized. If you're not taking it to get a serial number, you're in contravention of the law.
I agree.
Yeah.
So that if you were target
Then
shooting,
I'm okay with it.
yeah,
I just don't wanna leave a loophole.
Yeah.
right, that makes sense.
So I think I answered my own question. With this process going to the FFL, they still fall within a 3-day waiting period, right?
For the background
For
check.
the
For the
background.
background check, yes, that's still.
Sorry.
Mr. Chair?
Yeah.
Given that time is of the essence, I would move that the committee,
Support this
yeah.
amendment. All those in favor of supporting the amendment, say aye.
Aye.
Opposed?
No. 3 days, you almost got me. You almost got me.
I appreciate your consistency, Senator Norris.
We try.
All right, thank you, Eric, for the
Yes.
quick work on that. And we've
Of course.
got something we're supposed to go to at noon time.
Janet's surprise party.
Oh, shit.
And the floor is until 1, right? Is that right?
Floor is that one.
Wait, what?
What's, Janet, it's a surprise for Janet.
We're live,
Yeah, maybe.
What?
we're still live.
Oh, sorry.